North Carolina has one of the most clearly defined late fee frameworks in the country, with a specific statutory cap that provides certainty for both landlords and tenants. The governing law is found in the North Carolina Residential Rental Agreements Act, North Carolina General Statutes Chapter 42, Article 5, which includes a specific provision addressing late fee limits. If you're a landlord or tenant in North Carolina, the rules are straightforward and well-established. Let's start with the cap. Under North Carolina General Statutes Section 42-46, the landlord may charge a late fee, but the fee is capped based on the type of tenancy. For month-to-month tenancies, the maximum late fee is $15 or 5% of the monthly rent, whichever is greater. For tenancies longer than month-to-month, such as annual leases, the maximum is also $15, or 5% of the monthly rent, whichever is greater. This cap structure is important because of the floor. The $15 minimum means that even on very low rents, the landlord can charge at least $15. On a $300 rent, 5% would only be $15. So the floor and the percentage produce the same amount. On a $600 rent, 5% is $30, which exceeds the $15 floor, so the percentage controls. On a $1,500 rent, 5% is $75. The 5% cap means that on North Carolina's typical rents, which range from $800 to $1,600 in most markets, the maximum late fee ranges from $40 to $80. These are modest but meaningful amounts. North Carolina mandates a grace period. Under Section 42-46, the late fee cannot be imposed until the rent is more than 5 days past due. If rent is due on the 1st, the late fee cannot be charged until the 7th. The 5-day grace period is mandatory. The lease cannot shorten it. The lease can provide a longer grace period, but not shorter than 5 days. The statute also specifies that the late fee must be set forth in the rental agreement. The lease must state the fee amount or method of calculation. A late fee that isn't documented in the lease is not enforceable, period. Oral agreements about late fees do not satisfy the statutory requirement. North Carolina's statute includes a specific provision regarding partial payments. The late fee can only be charged on the amount of rent that is actually past due. If the tenant pays a portion of the rent within the grace period and the remainder late, the 5% cap applies to the amount that was actually late, not the full monthly rent. For example, if rent is $1,200 and the tenant pays $1,000 within the grace period, but the remaining $200 is late, the late fee is 5% of $200, which is $10. Since $10 is less than the $15 floor, the landlord can charge $15. The fee is not 5% of the full $1,200. This partial payment protection means that tenants who make good faith efforts to pay as much as they can are penalized only on the shortfall, not the total rent. It rewards partial compliance rather than treating a tenant who pays 90% on time the same as a tenant who pays nothing. North Carolina's statute specifically prohibits charging more than one late fee per late rental payment. The landlord cannot impose daily or weekly compounding charges. One fee per late payment, calculated at the statutory cap on the amount past due, that's the maximum. No compounding, no escalation, no additional penalties for continued lateness on the same month's rent. This anti-compounding provision is clear and absolute. Any lease language that purports to charge daily fees, weekly fees, or escalating penalties for continued non-payment of the same month's rent violates Section 42-46. Even if the tenant never disputes it, the provision is unenforceable. The interaction between late fees and the eviction process in North Carolina is governed by the state's summary ejectment procedure. Under North Carolina General Statutes Chapter 42, Article 3, the landlord can file for summary ejectment for non-payment. The landlord must demand the rent, and the amount demanded must be accurate. Including non-compliant late fees in the demand creates grounds for challenge. North Carolina requires a 10-day demand for non-payment before the landlord can file for summary ejectment, unless the lease specifies otherwise. The amount demanded must include only the unpaid rent and any legally compliant late fees. If the lease defines late fees as additional rent, they can be included. If not, the landlord should pursue the fees separately. North Carolina's tenant can pay all rent and fees owed up until the time the magistrate enters judgment, effectively a right of redemption. The amount needed to cure must be calculated correctly, including only compliant late fees. An inflated cure amount delays resolution and can result in the magistrate questioning the landlord's calculations. North Carolina limits the security deposit to 1.5 months' rent for month-to-month tenancies and 2 months' rent for tenancies longer than month-to-month. The deposit must be held in a trust account at a financial institution licensed in North Carolina. The landlord must return the deposit within 30 days and provide an itemized statement of deductions. Unpaid compliant late fees can be deducted. North Carolina requires the landlord to provide the tenant with the name and address of the bank where the deposit is held, within 30 days of the beginning of the tenancy. Failure to comply with the trust account and notice requirements can result in the landlord forfeiting the right to retain any portion of the deposit. For tenants receiving Housing Choice Voucher Assistance, North Carolina landlords should not charge late fees when the Housing Authority's portion is delayed due to processing. The fee applies only to the tenant's portion, and only if the tenant's portion is actually late beyond the 5-day grace period. North Carolina's military population is enormous. Fort Liberty, Camp Lejeune, Marine Corps Air Station Cherry Point, Seymour Johnson Air Force Base, and multiple other installations generate massive rental demand. The military influence on North Carolina's rental market cannot be overstated. Fort Liberty, formerly Fort Bragg, near Fayetteville, is one of the largest military installations in the world. The Fayetteville rental market is dominated by military tenants, whose BAH rates drive pricing. Military pay arrives on the 1st and 15th. Predictable and reliable. Late fee enforcement for military tenants is minimal. Camp Lejeune and MCAS Cherry Point in the Jacksonville and Havelock area generate significant Marine Corps rental demand. The Marine population is younger and more transient than the Army population at Fort Liberty, with more frequent PCS cycles. New Marines may need a month to establish direct deposit and allotment arrangements. Seymour Johnson AFB near Goldsboro generates Air Force demand. Numerous smaller Guard and Reserve facilities across the state add military tenants to local markets. Landlords near military installations should understand that the SCRA provides protections for active duty service members experiencing financial hardship. The standard 5-day grace period accommodates most minor military pay processing delays. From a practical standpoint, North Carolina's rental market has experienced strong growth, particularly in the Research Triangle and Charlotte Metro. Charlotte is the state's largest city with a booming economy driven by banking, Bank of America and Truist, healthcare, energy, and technology. Rents in Charlotte's desirable neighborhoods commonly range from $1,400 to $2,200. The 5% cap produces maximum fees of $70 to $110, meaningful but moderate. Charlotte's professional tenant base generally pays on time. Raleigh-Durham, the Research Triangle, has one of the strongest rental markets in the Southeast, driven by the universities, Research Triangle Park, technology, and healthcare. Rents are strong and the professional tenant base is reliable. Late fee enforcement is limited to a small percentage of tenants. Greensboro, Winston-Salem, and the Triad region have moderate markets with a mix of professional and working-class tenants. Late fee dynamics are straightforward. The statutory cap applies uniformly. Fayetteville's military market is dominated by Fort Liberty. Late fee enforcement is standard but minimal given the military population's payment reliability. Wilmington has a growing market with tourism and military influence from Camp Lejeune proximity. Asheville has a tight market with premium rents driven by tourism and quality of life appeal. College towns, Chapel Hill, Durham, Greenville, have student populations where financial aid timing affects early semester payments. The 5-day grace period covers most processing delays. One best practice for North Carolina landlords: set your late fee at exactly 5% of the monthly rent, which is the statutory maximum, and clearly document the 5-day grace period and the 1 fee per payment rule in your lease. The statute is clear, so your lease should match it exactly. Don't try to get creative with fee structures that might violate Section 42-46. Another best practice: calculate the fee on the amount actually past due, not the full rent, when a tenant makes a partial payment. This is what the statute requires. Set up your accounting system to track partial payments and calculate the fee correctly. A tenant who pays most of the rent on time and the small remainder late should be charged 5% of the remainder, not 5% of the full rent. A third best practice: never charge more than 1 late fee per late rent payment. No daily fees, no weekly fees, no escalating penalties. 1 fee, 1 time, calculated at 5% of the past due amount or $15, whichever is greater. Document the calculation for every late payment, showing the rent due, amount paid on time, amount past due, and the fee charged. This documentation supports clean eviction proceedings and prevents disputes. For the complete guide to North Carolina late fee laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our late fee law series.